This is a very interesting issue. I've really never run across something like this before, where they really have just out at the outset said, "Hey, man, if you blow and you're under, we're letting you go home," which is essentially what's happening here, right?
Yes, Judge.
Do you have any case law that says that it's okay to say that?
We have case law that says that the case that he used is overturned.
Judge, and we also have Sandoval v. State, which is from May of 2000 from the Court of Appeals of Texas, and it does.
You're saying May of 2000. When was this case?
I think that one's pretty old.
Oh, this is 95. Okay.
And it's
So
from
what case do you have? Can I
Sandoval.
see a copy?
Yeah, you can keep that.
Oh, I think I actually, Judge, may I hand you?
No. They're talking.
So Sandoval is almost the same thing as, or I forgot the last name, but
It's the same thing.
I already know your position.
so.
I'm trying to get theirs.
It states the same thing. And the officer in this case with the facts stated, if you blow under, you can go home. And the Court of Appeals held that the court did not abuse their discretion by letting in the breath test, that it was statutorily, it was outside the statute outside the statute requirements of the DIC reading, but that it didn't
A court
Directly.
found that was not.
abuse of discretion from the trial court. Yes, Judge, for Sandoval.
Okay, so but they let it in.
Yes, Judge.
Right. But is there something that says if it's let out, it's an abuse of discretion?
That, no, Judge. It's just case by case basis at this point.
Can I see it?
Yes.
Okay. So have you seen the cases that they cite here? Okay,
I know these cases. May I point something out to you?
sure.
Was that Navarro that you just read?
I think I'm looking at your Finian. I don't think it's on point. This is just whether this guy was more afraid about getting stuck by a needle, and that's why he wanted to blow as opposed to,
100%.
whereas this one's more on point where I think it go either way.
It's 100% on point. And then what I wanted to point out to you was, I believe that was Sandoval that you were just reading.
Yes, Sandoval.
Okay, so in the in the Sandoval case, the court said the only case we have found, the only case
Right.
they'd found concerning this very specific issue, the validity of consent given the hearing consequences of passing fail on a breath test, is State v. Sandoval. So they recognize that Sandoval is still good case law. They keep saying that Erdman overruled this case, and that's simply not true. This is still good case law, and I might also add Sandoval is in the Court of Appeals of Texas of Austin, and the case that I cited to you is the 14th Court of Appeals here in Houston, Texas.
Response?
Judge, nothing from defense, it is, sorry, from the state. It is really just something to consider for the court.
I'm ready to rule. I think it's totally coercive. Absolutely. There's just no, I've never seen something like it. Statement that, so I'm going to get locked up regardless, right? If you do breathe and you blow under, I'll take you home. If you do blow over on breath, then you're getting locked up. All right, I'll blow. If you blow under, quote unquote, I'm taking you home. If you blow over, you're getting booked in. If you do blood, you're getting booked in regardless, because blood takes 3 weeks, a month to come back. Yeah, I think it's totally, yeah. All right, I'm going to grant your motion as far as the breath.
Thank you, Your Honor.
Okay.
And Your Honor, just to maybe make this faster tomorrow, the state has also, we kind of touched on the motion in limine. And one of my motions in limine was to keep any testimony of the horizontal gaze nystagmus, the eye test, out of evidence because it was improperly performed twice. Once, the HGN that was given might as well have stood for here goes nothing, because that's kind of what it looked like. And then the second time, the horizontal gaze nystagmus test was just murdered.
We agreed to leave it out already.
So, okay, but I just wanted to clear that up for the record.
So just, admonish your officer accordingly. Hey, please don't get into this. And then that'll make it smooth. And then,
Absolutely.
okay. Anything else?
No.
No,
Okay.
Judge, and we also came, just for the record, we did come to an agreement as to where the body cam would be redacted.
Okay.
And the portion that is redacted includes some statements that were on defense's motion for limine. So it becomes moot at that point.
Got it. Just make sure you watch beforehand so that you're okay with everything, so that when we do watch, it goes smooth and we don't,
If I can get a copy of the one that they're going to offer into evidence today, I can
Do you
review it
have,
tomorrow.
do you have one
I
here?
do, I do not have a redacted portion of the body worn camera right now, but I can get it to you by the end of today.
That's
I
fine.
can send it to
That's
you.
fine. I'm good with that.
All right, guys. See you tomorrow.
We can take you right through that second. Honestly,
I don't think, look, have you seen what he's talking about?
Yes, and I just spoke with,
And is it as in the motion? Has he say, have you seen this?
that is a transcript.
the
Okay.
facts of the motion are as Lee said, it's, yes.
What do you think?
I actually just spoke to Alex and that case was recently overruled by
Yes, Judge, the Erdman case was overruled by the Court of Appeals, the Criminal Court of Appeals in 2012 by a case.
No. This is Serrano.
They cited that Erdman case, the underlying,
You talking about Simon? It didn't overrule Erdman.
they state,
No, it didn't.
and we can read it together. I would like to share it with the court. And
Last I checked, a Court of Appeals out of the Sixth Circuit or something does not overrule the Court of Criminal.
this is the Court of Criminal Appeals, Finan.
I'm sorry?
Finan is out of the Court of Criminal Appeals.
Okay, so tell me what it's, what's it?
One second. So.
Obviously, we'll give you time to look at it so you can.
Yeah, still up to you. I've read fine.
And I would like to share it with you. So it says the rules developed by Erdman's progeny are contrary to the fundamental rules of determining whether consent was rendered voluntary. Importantly, these rules, like the analysis of Erdman himself, overlook the fact that the voluntariness of consent must be analyzed based on the totality of circumstances.
That's
And,
what Sandoval says, my
Now,
friend.
hold on, let him finish. Let him finish.
and no statement, whether it refers to the consequences of refusing a blood test, the consequences of passing or failing a blood test, or otherwise, should be analyzed in isolation because its impact can only be understood when surrounding circumstances are accounted for. In other words, allowing any statement by itself to control the voluntariness analysis contradicts the basic rule that voluntariness must be determined based on case-specific consideration.
Sure, of course.
And then they explicitly say, therefore, because of its flawed reasoning and the flawed case law that results from it, we overrule Erdman, which is what that Serrano case relies upon, is Erdman.
So Judge, so Erdman, just, by the way, didn't overrule Erdman in its entirety. So what they're saying is the construct. So let's think about what Erdman was. In Erdman, the officer read a statutory warning. It said that if the person didn't give a breath test, that they were going to get blood. That's not coercive. That was reading the statute. So if you read the case that I cited, Serrano, and then there's Navarro after that.
So, and I want to give you time to look at everything, right? But I mean, this is right on point with this.
100%.
Right on point, right?
And
If Erdman is right on point with this, then, but if it's not right on point with this, then it's,
And Judge, then there's Sandoval as well. One of your sister courts just 2 days ago also ruled in an exact situation like this, where an officer gave the improper admonishments that, hey, you know, if you give a breath test, I'm going to take you home. And
okay,
that's what
so
was said.
I think that we're getting way ahead of each other. So let's, first off, we're not on the record, are we? We need to get up there. So, yeah, we're getting way ahead of ourselves. So, all right, Ramona, you ready? Guys, we're going on the record. If you want to talk, go outside, please. Yeah, yeah, as long you can confirm. Okay, I trust you. All right. We are on the record in cause number 2505428. State of Texas versus Stephen Garcia. Today is February 11th, 2025. It's approximately 9:49 in the morning, a.m. Guys, I'd like you to please announce yourselves for purposes of the record. State first.
Diana Davila for the state of Texas.
Mackenzie Watson for the state of Texas.
Jim Butler for Stephen Garcia.
So I think that we were getting ahead of ourselves here. We started without even going on the record. So today is day for trial. Both parties have announced ready?
Yes,
This should.
Okay.
we're ready.
So what we have here is just kind of a brief introduction and where
Today's case dives deep into a heated courtroom debate over something many drivers fear, the breath test. The defense says their client was misled by the officer, promised a free ride home if he blew under the limit. But the prosecution isn't backing down, arguing that the officer's statements didn't violate the law. Judge Boyd now faces a tough call. Was this a case of entrapment or just a misunderstanding? Stay tuned. The answer could change everything about how DWI stops are handled.
defense has challenged the breath test in this case and its admissibility thereof. You guys have reviewed everything outside, correct?
Judge, so just for the record, the state and the defense sat down in the back room and we kind of went through some of the motions. We went through the motion that I just filed, and then we also began going through the motions in limine. So, and then of course, we brought this motion to keep the breath test out, basically because the officer gave language that was outside the statutory language that they are supposed to give when they're offering somebody a breath test. And we're alleging that he basically tells my client, hey, look, if you blow, and if you blow under the legal limit, I'm going to put you in the car and take you home. And the evidence will show that my client relied upon that. In fact, at one point, when the officer is cuffing him and stuffing him, he's like, well, wait.
Here's where things get interesting. The defense is building its entire argument around reliance. In simple terms, the defendant claims he only agreed to take the breath test because the officer promised he'd be taken home if he passed. Legally, this raises a big issue. Officers are required to read a statutory warning, nothing more. Any extra language, especially something that sounds like a deal, could be seen as coercive. But proving that the defendant's decision was directly influenced by that promise, that's the tricky part. What do you think? Was this officer bending the rules or just trying to cooperate?
Wait a minute, you said I was going to get to give a breath test because he believed that he was under the limit, wasn't going to register, over 0.08, and was relying on the fact that if he gave that test, all of this ended and the officer would cut him loose and take him home. And then, of course, after that, and after the officer said, no, we got to go downtown because our machine's downtown, he again repeated that and said, look, if you blow under, we're going to get in the car and I'm going to take you home. And again, repeated that. And my client relied upon that and thought that that would happen. Of course, that's not what's going to happen. And Judge, and based on your experience, it's also possible that he could go down there and blow under the legal limit and the DA could still accept charges for DWI. So that was impermissible language that should not have been given in this case. And one other thing.
And if you're not ready yet, it's okay, because I know that we're
Okay,
kind
I was
of,
just giving her the opportunity of what she wants to do. We did review the facts on the motion. We agree that the facts stated were as reflected on defense's motion. However, we do disagree with the case law given to support the fact that just because of the statements given by the officer, the breath test should be excluded. The underlying case law has negative treatment by the Texas Criminal Court of Appeals, and there is other cases within the same jurisdiction that have different treatment. However, we have come to the agreement that because what the case given by defense, once it goes upon appeal, it is only reviewed for abuse of discretion, and the case that overruled or gave negative treatment to Erdman says the same thing. Basically, it is the totality of the circumstances, and if you're able to relate a certain link between what was specifically said to the officer and what the defendant believed to be true, and if that gave him a specific idea.
Now, Judge Boyd's analysis here is textbook judicial balance. He's not just weighing what the officer said, but how those words might have impacted the defendant's decision. This is where the law gets gray, intent versus interpretation. Was the officer's statement, "I'll take you home if you blow," under a friendly reassurance or a subtle pressure tactic? The court must decide if those few words tainted the evidence. And remember, under Texas law, one misstep in phrasing can lead to a key piece of evidence being thrown out entirely. So yeah, the stakes couldn't be higher in this debate.
Of what was going to happen, or moved him towards the direction of the breath test versus the blood test. So I think we're both in agreement that the only way to resolve it is by you reviewing what was exactly said by the officer on the timestamp was given and using the court's discretion to come to the
Let
conclusion.
me ask you this. Have you had a chance to see whether Serrano, the case that he provided, it's right on point? Have you
It has not been
seen?
overruled, just so you know. And I think just to give you a little more information. So I agreed with that treatment of Erdman. I thought that it was not that great of a case because in Erdman, look, you had a officer that was doing nothing more than reading the statutory language. He wasn't even saying like, hey, go down there and give a sample. And if you are under, I'm going to take you home, which is like dangling candy in front of a baby. And that's the kind of thing that the law wants to prevent. The law says, here's the statute that you read. Navarro, which is another case that's cited among the cases that we're talking about.
I understand that. Is there something that negates Serrano? Is there a case that says, hey, saying something like this is okay?
It would just be Finan, which is the Texas Criminal Appeals case that just states that it was not a breach of discretion to keep it out and that it would have to be a totality of the circumstances.
Okay.
And we 100% agree with that, and we know that. And so, Judge, what the other thing that I wanted to say without going into Erdman is the Navarro case talks about, it's very good, and it talks about what the statutory language should be and why it is there and what it informs the person. If you give a test and if it's over the limit, here are the consequences of that. If you refuse the test, here are the consequences with your driver's license. And then, you know, if you refuse, you're going to we can get a warrant to get your blood. That's all they're supposed to give them. And then they sit back and then the person either agrees or they don't agree. You can't sit there and then start enticing the person by telling them things to get them to change their mind. And clearly you're going to see that on the video. This officer says these extrajudicial statements. Hey, if we go down there and if you blow over or under, pardon me, we're going to get in the car and I'm going to take you home. Now, if you blow over, you're going to be arrested. But if you ask for a blood test, then you're also going to go to jail. And, you know, it could be a week or however long before that blood comes back. So he's thinking, man, I better go down there and give a breath because I'm going to go home. And you just can't be saying stuff like that.
We have a panel here ready to go. So I don't want to keep them waiting. They've already been waiting for 30 minutes. So how do you guys want to proceed?
Judge, if it's okay with you, I'm
Are
happy.
you ready to argue the merits of this? Because what I was going to suggest is that we go ahead, pick the jury, and then we can just start and finish argument with this
Well,
right after we're
the only thing that
I don't want to keep them waiting.
no, I understand that. The only thing is that kind of does change the voir dire a bit, doesn't it?
If you want to exclude the breath test part of your voir dire, then I guess it can be talked about. It's not totally excluded, even if it gets excluded, because we can't force them into specific facts that
No,
there
of
is no
course,
breath
of
test.
course.
So I think.
I guess we're ready to roll, and then we can enforce.
I just want to keep them waiting. Let's get it started, and then right after we get done with the paneling, then we can, and then that'll give you more time to look to see if there's something else that you want to look at as far as case law or whatnot.
And Judge, we'll print a copy for the court of the two outstanding case law that we have.
For sure. Okay.